Thank you, Jolene. Thank you, Cheryl. As we prepare to introduce our keynote speaker this morning, I want to just give you a brief background of what we can expect to hear. We've talked a lot about courts being essential to our democracy and the system of justice, but all too often they act as sites of injustice. At the same time, pressures from within and from the outside threaten our court's capacity and our independence. All of us have experiences, particularly over the last 3 years, where the independent yet accountable judiciary has been challenged. Our communities are looking to us as court leaders to address and overcome these challenges. We're going to begin today by looking at recent trends and how courts can lead the way in promoting a fair and more inclusive system. The next step that follows that is to effectively communicate that value of an independent and yet accountable judiciary to our communities. Guiding us this morning on our journey is the director of the Judiciary Program at the Brennan Center for Justice at the NYU School of Law, Ms. Alicia Bannon. Ms. Bannon is a widely published expert appearing in the New York Times, the Washington Post, and Time Magazine on subjects such as court reform, access to justice, and fair representation of government. She will also talk to us about the launch of the Brennan Center's State Court Report, which focuses on state constitutional development. It's my pleasure to introduce to you Ms. Alicia Bannon.
Good morning. Thank you so much for that very generous introduction, and thank you to NACM for the opportunity to speak with you all here today. It really is an honor. As you've heard, my name is Alicia Bannon, and I direct the Judiciary Program at the Brennan Center for Justice. For those who aren't familiar with the Brennan Center, we are a law and policy institute that works to improve our systems of democracy and justice. And our judiciary program works to realize a fair and inclusive judicial system that protects fundamental rights and democratic values. I want to start us today with our reason for being here, what I think has brought everybody to this room early on a Monday morning, which is a recognition of the critical importance that courts play in our legal and political system. We urgently need fair courts to protect rights, hear cases impartially, and uphold the rule of law. I wanted to start with a quote from Justice Sandra Day O'Connor, one of my favorite quotes about the judicial system. She says, "The founders realized that there has to be some place where being right is more important than being popular or powerful, where fairness trumps strength. And in our country, that place is supposed to be the courtroom." And I want to pause because that's an important, profound statement about the role of courts in our democracy, in our system. It's not supposed to matter how powerful you are, how popular you are. In the courtroom, what's supposed to matter is the law and the facts. And in the courtroom, that is the job of the court is to do what's fair and do what's right. And we see that manifested in, the statues of Lady Justice who's blind. We see that on the top of the Supreme Court's building in Washington, D.C., where it declares equal justice under law. And that matters deeply. Courts are hearing everything from multi-million-dollar commercial disputes to a legal challenge to a state's abortion restrictions to a child custody dispute. And all of those different rulings have all of those cases, and the way that the courts decide those cases has a profound impact on people's lives, their opportunities, and in many instances, their rights. Now, sometimes courts have fulfilled that promise of equal justice under law. You can think about the moral clarity of Brown v. Board of Education. You can think about Obergefell, where many same-sex couples actually quote from that ruling in their own marriage ceremonies. And you can think about many everyday interactions, somebody who gets the money they're owed, the protections that they've needed. Plenty of times where people have turned to courts to demand vindication of their rights and received justice. At the same time, for many people, in many instances, courts have not been that experience of equal justice under law. That hasn't been their experience of the courtroom in our justice system. Consider the story of Twanda Marshinda Brown, a single mom who was working at a Burger King in Lexington County, South Carolina. She was ordered by a court to pay $2,300 for 2 traffic offenses. She told the court she could only afford to pay about $50 a month. The judge ordered $100 per month. She managed to make 5 payments before life interfered. Her son was hospitalized, some checks from her employer bounced, and she fell behind on her payments. She was arrested by the sheriff's office and brought before the court. She was ordered to pay $1,900 immediately. She didn't get a court hearing on her ability to pay. She was never given that opportunity to make that showing. And she simply didn't have the money. As a result, she spent 57 days in jail. During that time, she lost her job, and with it, an opportunity to get a promotion and raise that she had been angling for. Every day in jail, she worried that her 13-year-old son was going to be taken away from her. All because she didn't have the money to pay a traffic fine. There's now a federal lawsuit that's pending in which Brown is the plaintiff challenging these practices. That kind of everyday injustice is part of our legal system too, part of our judicial system too. So I'm going to speak today about some of the ways that our courts are under pressure right now. And that includes challenges from the inside, ways in which courts are not meeting that promise of equal justice. And that's going to include challenges from the outside, external pressures from state legislatures, from special interests, from many political forces that have been challenging judicial independence and the capacity of judges and courts to play the crucial role that they're supposed to play in our legal system. And be prepared, I'm going to talk about a lot of trends. It's going to get a little depressing at times. But ultimately, I want this talk to be a source of optimism, because I'm also going to talk about some of the steps that all of us, court managers, judges, as well as lawyers and members of the public, can take to promote a fairer and more inclusive judicial system. Courts are too important. These issues are too important not to give it the attention that it needs. And it is within our power to build a more equitable system. So first, some trends. Where do we stand now? One thing to highlight are trends about legitimacy. There are some troubling indications that courts right now are facing a crisis of public legitimacy, a crisis of public confidence. I'll start us here with a survey by the National Center for State Courts, which has been surveying public trust in the courts for many years. They've asked a question for many years about whether courts are providing equal justice. And if you look at the table here, the chart here, this year the lines crossed. So more people thought that courts were not providing equal justice than those who thought they were. That's a big deal for courts. Public confidence is really the currency that courts operate in. Courts don't have an army. They don't have the power of the purse. What they have is public trust that when a judge says, when a court has a ruling, even if you disagree with it, that you need to accept that ruling, accept the outcome of the case. And that public trust in the court is also vitally important when courts are seeking resources, when courts are seeking the support that they need in order to enhance access to justice. And when courts are pushing back against some of the trends I'll be talking about later, where we've seen really troubling efforts by many legislatures to politically interfere in courts. If you don't have that well of public trust and public support for the judiciary, courts are in a very vulnerable position to defend themselves and advocate for the resources and support that they need. So why is public trust in courts declining? That would be, that's a dissertation topic in itself, and I'm not going to purport to cover every reason, but I'm going to highlight a few. The first point I want to raise is the impact of the US Supreme Court and how I think we're seeing a trickle-down effect from perceptions of the US Supreme Court for court systems writ large. Now, in the past few years, we've seen a dramatic rightward turn on the US Supreme Court, a conservative supermajority that in many instances has been quite radical. And I'm sure there are plenty of views in the room about cases like Dobbs, about the wisdom of some of the decisions that the court has made. But what I think we can all agree on is that a decision like Dobbs has been a legal tsunami. I think it upended a lot of people's expectations about their rights, about the legal system, about the role of the courts. And what we've seen is that that legal tsunami, those kinds of decisions, have affected how the public is perceiving the US Supreme Court. So for example, in this same National Center for State Courts survey, 5 years ago, there was virtually no difference in views of the Supreme Court based on ideology. Conservatives, liberals, very similar takes on the Supreme Court. Since then, confidence in the Supreme Court has fallen about 3 points among conservatives, 25 points among moderates, and 45 points among liberals. A study by Pew gets at, and we see this represented in some of the in recent instances, record levels of disapproval for the US Supreme Court. A study by Pew gets at some of the reason why we might see that public trust falling. Overwhelmingly, the public thinks that the US Supreme Court is deciding cases based on their political views. And they don't think they should be doing that. 84% of adults say that justices should not bring their own political views into the cases they decide. But only 16% of those people say that they're actually doing that. So overwhelmingly, people are perceiving the US Supreme Court as bringing politics into judging. And this concern isn't coming out of nowhere. This is the first time in modern history, for example, where the ideological composition of the US Supreme Court perfectly aligns with the political party of the president who nominated them. This is also the first time that we've seen justices conservatively aligned across a wide array of high-profile, high-salience issues. And that too is new. So, just a little over a decade ago, you had the Shelby County decision, where the Supreme Court gutted the Voting Rights Act. People like the Brennan Center were very critical, thought that was a terrible decision. But the same year, the court had the Windsor decision, striking down the Defense of Marriage Act. On a wide array of issues, you had issues that were conservative and liberal, where sometimes you'd win and sometimes you'd lose. And what we're increasingly seeing with the conservative supermajority is that consistently, one side is now winning and one side is now losing. And that's impacting public perceptions of that institution. You've also seen trends in terms of the behavior of the Supreme Court. Obviously, one example is the rise of the so-called shadow docket, where there's been a notable increase in the Supreme Court taking on emergency motions, emergency cases, without the benefit of full briefing. So rather than having full opinions, full briefing, full transparency, you've seen a rise of cases decided very quickly without the benefit of those transparency norms. And that too is contributing to a perception that the court is overlooking procedure, overlooking some of the norms of restraint that have traditionally encouraged moderation on the part of the judicial branch. And why does that matter for people who don't, for people outside of the Supreme Court? Why does that matter for all of the courts? Because what we know about courts is what happens in the Supreme Court does not stay in the Supreme Court. Ordinary people don't distinguish between state courts and federal courts, trial courts and appellate courts. So if large swaths of the public think that the Supreme Court is political, that is a concerning trend for the entire judicial system, for courts across the country, because that's going to contribute to a broader public perception that the courts as a whole are political. Now, of course, that's not the only legitimacy challenge facing the courts. And again, I could write a dissertation, so this is only going to be a piece of the story, but I wanted to lift out another trend that I think is really important for understanding the legitimacy challenges that state courts are facing right now. Another component of that challenge is the court's role in racial justice in our system. So for example, the National Center for State Courts also highlights racial disparities in perceptions of our judicial system. Confidence in the Supreme Court, for example, dropped 9 points among white voters and 19 points among black voters. For state courts, it was 2 points among white voters and 7 points among black voters. And that builds on historic disparities in public confidence between communities of color and white communities. Now, again, there are a lot of reasons for that. One certainly is a trend of systemic racism in our justice system writ large, which isn't only about the courts, but certainly in which the courts are one piece. Judge-made doctrines like qualified immunity have made it harder to hold police officers accountable for misconduct. We talked earlier about the court's participation in often highly racialized fees and fines regimes. There's been a troubling trend in many jurisdictions of courts' failures to stop prosecutorial misconduct. So while courts are not the entirety of that system, courts are a player in that system. And as we see a lack of trust in our justice system writ large, that too has an impact on how individuals are perceiving the courts. Another dimension of that has to do with diversity. Diversity on the bench, as well as diversity in courthouses writ large among court staff, people's experiences when they enter the courthouse doors and who they're interacting with, who's representing our system. There is a stark lack of diversity within our court systems at all levels. To give a couple of examples, looking here, this is data on the federal courts looking at racial and gender diversity, where we have still roughly 70% of all federal judges are white. They make up about 60% of the population nationwide, and more than 60% are male. In many state courts, the numbers are even more stark. The Brennan Center has been collecting data on state Supreme Court diversity across the country. And we found back in May of last year, so the last time that we updated data, that there were 20 states where there was not a single person of color on their state Supreme Court. And that included 12 states where people of color made up at least 20% of the state's population. 28 states where there are no black justices, 39 states where there are no Latino justices, 43 states where there were no Asian justices, 47 states where there were no Native American justices. Across all state high courts, only 18% of justices are people of color. Again, nationally, the number is about 40% in the total population. Men hold about 59% of state Supreme Court seats. In 9 states, there's only 1 woman on the state Supreme Court bench. And this data is old, but I'll highlight in South Carolina, we are just now, due to a change in a retirement of 1 justice, we are just now having an all-male state Supreme Court in the state of South Carolina. This too matters for public perception of the legitimacy of the courts. Courts have a tremendous impact in people's lives. And it is a big challenge to courts' legitimacy when people go into that courtroom and the people who are making those decisions, the people with that power, don't look like the communities that are being impacted. It can be very hard to make the case that courts understand the full implications of their decisions, understand the stakes for the people that are appearing before them, when you don't have adequate representation of the communities that are being impacted by these decisions. Now, there's also a series of threats coming to courts from the outside. So I'm going to spend a little bit of time now talking about a different set of trends. Assaults on judicial independence from state legislatures, ways in which we're seeing politics targeting courts in a way that's really troubling and to a large degree unprecedented, as well as a troubling trend of the politicization of judicial elections. And I'm going to make the case that these trends, too, are clear and present dangers to that promise of equal justice under law and to the judicial independence that we need for courts to function well and play the role that they're supposed to play in our democracy. This is both a symptom and a cause of some of the legitimacy crises that I've been talking about. And there's a real urgency for all of us, for court managers, for judges, and for members of the public to mobilize to defend courts against some of these threats. But again, to be in a good, strong position to defend those courts, courts also need to be grappling with some of the access to justice issues that make a lot of people not trust those courts very much to begin with. And so I think that's part of the call to action that we have to grapple with today. So in recent years, we've seen a consistent and growing trend of state legislatures targeting the power and independence of state courts, often for unpopular decisions, sometimes very specifically in retaliation for particular decisions, often in efforts to gain more political control over those courts or over the judicial selection process. To give just a couple of examples, in North Carolina, just in the past few years, we've seen successful efforts to change the size of the intermediate appellate court for political purposes, the reintroduction of partisan elections. There was an unsuccessful effort to pack the state Supreme Court, as well as unsuccessful efforts to gerrymander judicial districts and shorten the term of judges in the state. After recent cases, we've also seen a surge of calls for impeachment of some of the judges, again, because of disagreement with some of the decisions coming out of that court. In Alaska, recently, a few years ago now, the governor vetoed $300,000 from the state court's budget in response to a decision blocking restrictions on Medicaid funding for abortion. The governor essentially tallied up how much money that state funding was going to cost and then slashed it from the judiciary's budget. Now that one, there was a lawsuit filed and ultimately that decision was struck down. But that's the kind of targeting that we're seeing in states across the country. In Kansas, we've seen efforts to take away the court's budgetary and administrative authority, and similarly efforts that tied the court's budget to the outcomes of rulings in particular cases, putting a non-severability provision. So if you strike down the ruling, the court loses part of its budget. In 2022, legislators in 25 states considered at least 74 bills that targeted state courts. And that included everything from efforts to limit courts' jurisdiction, their power, interfering with their decision-making authority, targeting court resources, gerrymandering efforts to change the forums for different cases in a way to change who is hearing particular cases, as well as a number of efforts to get more political control over judicial selection. 5 of those bills became law in 3 states in 2022. An additional 22 bills advanced in a significant way, passing a branch or coming out of committee or receiving a hearing or passing through one house of the legislature. One trend that we've seen in particular in all of these different targetings is a new attention towards courts' roles in election cases. This came particularly coming out of the 2020 election, where, as you might recall, in a number of states, there was litigation to change election administration rules in response to the pandemic. And in response, in 2022, and then to a lesser extent last year as well, we saw a number of bills that sought to weaken courts' power in election-related cases, taking away their power, creating new tribunals, or targeting particular judges, seeking to remove judges from the bench based on particular decisions that they made in election cases. 4 of those bills were enacted in 4 states. So in Georgia, it became more difficult for judges to use their power to extend polling place hours. And in Kansas, Kentucky, and Texas, there were new laws that prohibited judges from altering or suspending state election laws, even if they deemed that that the state constitution or federal constitution required it. In 2022, those trends continued, and we also saw new attention to state courts' power over reproductive rights cases. So in Oklahoma, for example, there were 2 anti-abortion bills that were modeled off of Texas's SB 8. Both of the Oklahoma provisions explicitly prohibited state courts from hearing lawsuits to stop the enforcement of those laws. So essentially trying to insulate those laws from any kind of state legal challenge. And of course, state legislatures aren't the only people who've been active. I mentioned in Alaska, governors' use of line item veto authority and other kinds of executive actions to target state courts. We've also seen a really troubling trend in several states where political leaders have sought to defy court orders, simply announcing they would not abide by them, ignoring court orders, refusing to even appear in court after courts ordered them to do so. So it gives you a sense of just how politicized and tense the dynamics have gotten in a number of states across the country. And looking forward into 2023, it's still early, so a lot of state legislatures are just getting started, but we're already starting to see some of these trends play out this year in states like Kansas, Montana, and South Carolina. So in Kansas, we've seen bills introduced to make it easier to target judges for unpopular decisions. Montana, we've seen bills to change judicial selection in the state, change judges' terms, as well as bills that would seek to make it easier to recall judges from the bench. South Carolina, we've seen bills that are focused on merit selection, on the structure of judicial nominating commissions, seeking to give politicians more control over those commissions so that they are not able to sort of vet in the independent way that they're supposed to function. So this is just, some sense of some of the political forces that courts are facing right now, and really troubling efforts to retaliate for decisions that are coming out of the courts, and put more political and have more political attention and interference in the decisions that those courts are making. And as I said as well, resources for courts can loom large upon these as well. When you have these back and forths, these political fights, when courts are seen as kind of mixed up in these political battles, that can make it much harder for courts to successfully advocate for the resources that they need to promote access to justice and to build the public confidence that is so essential to the functioning of our system. I'm going to give one more threat, and then I'm going to turn to some hope, because I don't want to get the crowd too down right now, but I think there's one more trend that's really important to understand as we're thinking about some of the threats that courts are facing right now to the promise of equal justice. The last threat I want to highlight is one that stems from judicial selection and the politicization of judicial selection. Now, obviously, we've seen that play out in the federal courts, the standoff over Judge Garland's nomination to the Supreme Court, the increasing vitriol surrounding federal judicial nominations. What's gotten a lot less attention is the politicization of state-level judicial selection, and particularly state Supreme Courts, and particularly state Supreme Court elections. So as some of you may know, there's a wide set of systems that states use to choose their judges. But the majority of states include elections as one part of how they choose judges. So 38 states have elections as some component of their system. For many, that involves contested elections, kind of similar to what we see in ordinary political contests, where you'll have multiple candidates vying for a seat on the bench. Most of those elections are nonpartisan. In a few states, they're partisan. And then in other states, we have so-called merit retention systems, where judges first reach the bench through an appointment process, where candidates are vetted by a nominating commission and then appointed by the governor, and then they stand for periodic retention elections, up or down votes. The remaining states have some form of appointment system. And what we've seen in states across the country, and that includes contested elections as well as retention elections, is a really troubling increase in money, in politicization, in special interest attention on those judicial elections, which I would argue as well is a very serious threat to both the appearance and the reality of equal justice under law. So sometimes a picture or a video can be worth 1,000 words. So I'm going to start us off with a video, a short advertisement that came from a judicial election last year in Alabama, a primary, from Judge Deborah Jones, who is running for the state Supreme Court. Now, I would say this is a more extreme example of some of the ads that we see, but I think does reflect kind of the direction of the tenor that we're seeing in a lot of judicial contests across the country.
Judge Deborah Jones is an experienced conservative judge running for the Alabama Supreme Court. If you're looking for a pro-Trump conservative fighter, she's 5 feet of concrete. Judge Jones once put a child molester in prison for 1,008 years. Why only 1,000 years?
Because the liberals wouldn't let me put him under the jail.
Judge Deborah Jones, conservative fighter, tough on crime, and she'll stand tall with President Trump.
So what is going on in this ad? Let's pause for a minute and unpack some of what I think is really troubling. Obviously, it is unusual for a judicial candidate to suggest that she wished she could have shot one of the defendants who had appeared before her. But stepping back, think about that. This is a sitting judge in the state of Alabama. If you were appearing before her in a criminal case, if you had a family member that was appearing before her, do you really trust that you would be able to get a fair hearing? Is this ad contributing to public trust in equal justice under law? And look at the close ties to prominent political partisan figures. Again, the role of a court is to decide cases based on the law and the facts in front of them, not based on political partisan preferences. And when we see judges, and this happens on both sides, when we see judges campaigning, drawing on political leaders, signaling their partisan associations, that can do real damage to public confidence that courts are actually playing a different role in our political system than the political branches of government. And we need courts to be playing that different role. So this is, like I said, one of the more extreme ads, but it's actually has a lot of threads that we see in judicial campaigns across the country. The emphasis on tough on crime, suggestions, perhaps line-crossing suggestions about how they, what they would have done if they could have in particular cases. The nodding towards partisan political issues that are highly divisive, sending those clear ideological signals. Now, how did we get here? Much of the story is about the rise of money in judicial elections. And that's something that we've seen a dramatic increase over the last 2 decades. This comes from a study that we did looking, from the start of the 2000s through 2016, and these numbers were all inflation adjusted, where we saw in 1999, there were 7 states where there was at least 1 judge on a state high court that had been involved in a $1 million election. And by 2016, it was 20 states. Over a third of sitting justices in states that have elections have been involved in at least $1 million election. And that really matters. That means that judges that are hearing cases have to worry about dialing for dollars, have to worry about campaigning. They have to look over their shoulder about what particular decisions are going to mean for their ability to raise more money, to get support from outside interest groups. And if they rule in particular cases that in ways that might be unpopular, that they may get a target and a lot of outside money targeting them for rulings that they've made. Part of the story is a Citizens United story. So we've seen a dramatic uptick after Citizens United in the role of outside money, special interest money, pouring into state Supreme Court elections across the country. And what we found too is that overwhelmingly, that money that comes from outside special interests is non-transparent. We did a study where we tried to unpeel the onion, see who is behind a lot of this money. In 80% of the instances, that money was untransparent. Either it was spending by a completely dark money group where you had no information about the donors, or it was what we sometimes call gray money. They disclosed their donors, but their donors were another group. And you had to keep unpeeling the onion and oftentimes could never even get to ultimately who was the real source behind that spending. Why that's concerning for a lot of reasons. One is that the rise of outside spending has absolutely impacted the tenor of these judicial elections, the kind of advertisements that we're seeing. Outside groups are far more likely to go negative than candidates themselves. They're far more likely to target judges' decisions, to attack them, often in very misleading ways. Outside money, in particular dark money, can also obscure conflicts of interest and create a perception that you may have, you may have actors who have very clear interests in cases before the court that are spending money trying to influence who sits on the bench. And without any kind of public accountability, and even perhaps without the awareness of the judge themselves about who's actually seeking to influence their elections. I mentioned misleading ads and wanted to just go into a little more detail about one that came from a 2016 Washington State Supreme Court race, where Justice Wiggins was attacked for a ruling in a case where he had decided, and he writing for the majority, a ruling on a Fourth Amendment issue, a search and seizure issue in a criminal case. The ad caricatured his ruling as enabling child predators, because the case involved somebody who was involved in abuse of minors. The ad didn't focus on was his analysis of the Fourth Amendment correct? Was it defensible? What they did was say, well, you reached an outcome where a bad guy got free, and so public, this person enables child predators. And it prompted a very strong rebuke from including a former US attorney and other former justices on the court saying, this is really misleading. This is not fairly representing what Justice Wiggins did, what the role of the court is. You're conflating a particular outcome in a case with whether or not the judge's reasoning, the applying of law and facts, was appropriate. One of the reasons why this is so troubling, and coming back to that value of equal justice under law, is that there's a growing body of empirical research that these kinds of election pressures can impact judicial decision-making. Maybe not consciously, but that those kinds of pressures are real. Judges sentence more harshly in election years. There are studies finding as there's more money that goes into state Supreme Court elections, justices have been more likely to vote against criminal defendants in appeals that are coming before them. There have been studies that have found judges are more likely to vote on the side of campaign contributors or political parties that have supported their interests. And what we found in many of these studies is when judges are term limited, when they're not going to face another election, the behavior changes, which suggests that this isn't, just a confounding variable, but that there's something about those reselection pressures that are having an impact on how judges are actually ruling, that are having an impact on that equal justice under law. Judicial elections are also part of the story of what I was saying with respect to diversity on the bench earlier in my remarks. We've documented there are wide racial disparities in how judicial elections operate. Racial disparities in who runs, who wins, who's more likely to be challenged, who is most successful in raising money, and who's most successful in attracting outside spending in support of their elections. And of course, I've focused most of my remarks on judicial elections, but judicial appointments are not immune from all of this. Obviously, in the federal courts, we've seen highly politicized judicial appointments, but we're seeing similar trends play out in some of the states, where increasingly judicial appointments, even in states that use judicial nominating commissions and have systems that are supposed to take some of the political influence out of the process, we're seeing increasing political attention on these appointments, increasing activity by outside advocacy groups seeking to impact who's reaching the bench in a way that is tying all of these courts more and more up in the rough and tumble of politics. And again, judges aren't supposed to be politicians. So we have a real challenge when judges and courts are increasingly perceived and increasingly face pressure to behave more like politicians. That can affect public perception of equal justice under law, and it can put real pressure on courts in terms of meeting that essential promise of deciding cases on the law and the facts in front of you. So as I hope I've made clear, courts are vital to the functioning of our democracy, but for a lot of reasons, that promise of equal justice is often not being realized. But like I said, I don't want to leave us on a low note. I don't want to create a feeling of despair. I want to create a feeling of call to action. Because the truth is that court managers and judges and the public, all of us, have a lot of power in our hands to create a fairer and more equitable system so that equal justice under law is more than just a phrase over the courthouse door. So first, I want to give some examples of ways that courts and judges have been, can be, and have been leaders in promoting access to justice, in ensuring fair cases, courts that the public can be confident in. I start with a quote from Judge Nancy Gertner, a former federal judge who now teaches at Harvard. She highlights the role that courts play as managers. You know, I think sometimes we think of courts, or the public sort of thinks of courts as just sort of this neutral force where things are coming in front of them. But obviously, that's not the reality of how courts function. Cases get managed, and there's a huge amount of power that we have to shape how those cases get managed, and in particular to think about resources. So in this particular quote, Judge Gertner is talking about the role that judges can play in ensuring equitable resources in criminal cases. And that she encourages judges to think about really playing an active role in making sure that proceedings are fair, and that might require affirmative intervention by judges and affirmative intervention by court managers and other stakeholders within our system to make sure that all of the participants are sufficiently resourced that they can make their case and have before the court fairly put in front of them the laws and the facts so that the court can actually reach a just and fair outcome. I'm going to play next a video from Chief Justice Stephen Gonzalez from the Washington State Supreme Court. I had the opportunity to interview him a few months ago, and he had, I thought, some really interesting reflections, both on the role that courts can play in addressing injustice in our system writ large, as well as a specific example of advocacy that he was involved in as a judge around addressing ICE arrests in courthouses. And more generally, I think he had what I thought was a really compelling call to leadership for courts. And so rather than speak for him, I wanted to give you the chance to hear some of his words.
There's a substantial amount of work that still needs to be done. And I think the difficulty in it is that as a profession, we're fairly conservative. We're trained, we're taught for 3 years and then years after that in practice to be backward looking. And so we're stumbling forward, walking backwards, looking back at where we've been, trying to predict what we might trip over next. And we can't possibly predict the trunk or the vine that's going to trip us up that way. I think occasionally we have to look over our shoulder or even turn around and see what we're facing. So resisting our natural temptation to say, oh, we can't do that, that's outside of our realm, I think is hard work. I remember it came up when I was a trial court judge, and I and a couple of my colleagues proposed a rule to prohibit ICE from arresting people in or around our courthouses, because we wanted everyone to feel liberty to come to court and adjudicate their disputes peacefully without the specter of federal enforcement. And some of my colleagues on the trial bench said, well, we can't do that. That's a political question. But just because immigration status has been politicized, it doesn't mean access to justice is political. And so eventually we did pass it, and Homeland Security agreed to honor that policy, at least until the most recent administration before the current one, who went back on that deal, but we again have their agreement to respect that policy. So I think it's important for courts to be a bit courageous on issues like that and say our job is to provide a forum for people to resolve their disputes. Therefore, it's problematic for us to be enmeshed with and involved in immigration enforcement, because it will mean witnesses won't come, victims won't come, parents won't come to support their kids in juvenile court. And so as a policy matter, that is an access to justice issue well within our wheelhouse. So thinking through those kinds of issues are the big challenges. It takes bravery, courage, dedication, and a great deal of patience to move something like the judicial branch.
So moving on to some other examples. New Jersey. In 2020, the New Jersey Supreme Court, after the murder of George Floyd, made a public commitment to eradicate systemic barriers in their system of justice, and recently put out a report that details much work left to do, but also key measures of progress, including vacating certain juvenile fines, we talked about fees and fines, and expungement of certain marijuana-related crimes. I also want to highlight ways that courts are grappling with a history of systemic injustice and racism in our system, and ways that courts have been complicit with that in our history. Here's a story of Hanyan Chang, who is the first Chinese immigrant licensed to practice law in the United States, who was denied admission to the California bar. Hanyan Chang first came to the US as part of an education program developed by the Chinese government. He was brought back to China after that program ended, but came back later to the US on his own to study law at Columbia Law School. He was admitted to the New York bar, but then he moved to California. He sought admission there because he wanted to practice law in California. But in 1890, his request was denied, because at that point, admission to the bar required citizenship, and he was ineligible for citizenship under the Chinese Exclusion Act. Now, in 2011, students at UC Davis learned about his story, learned about his case, and petitioned the California Supreme Court to posthumously admit him to the bar. And it did so in 2015. And it did so with, I thought, very powerful words. It's past time to acknowledge it was a grievous wrong. It denied Chang equal protection of the laws. It was a blow to countless others who aspired to become a lawyer, only to have their dream deferred on account of their race, alienage, or nationality. And it was a loss to our communities and to society as a whole. So it's one example, a small example, but I think a powerful one, of a court very explicitly grappling with its history and its role in an act of discrimination. Now, courts aren't the only actors who can play a really critical role in addressing some of the trends that I was talking about and ensuring that we meet the promise of equal justice under law. We've seen action from state legislatures. So for example, in 2020, the New York legislature passed a law requiring the collection and publication of diversity data for the New York court system. Many state courts across the country don't collect or at least make public that data, which can be a real challenge in terms of transparency and accountability. And in New York, the legislature stepped in and set these legal requirements in place so that now in New York State, we have that information and advocates and others can use it to hold their officials accountable and look at what the courts look like and call to action if you see courts that aren't reflecting the diversity of the communities that they're supposed to serve. We've also seen real progress in some states, as well as on the federal bench, in bringing greater diversity to the bench. So for example, President Biden, as compared to both President Obama and President Trump, has a quite striking record in terms of bringing greater racial, ethnic, and gender diversity, as well as professional diversity, to the federal bench. And I think it's a powerful example that oftentimes, in order to achieve diversity on the bench, it's not really an issue that the pipeline isn't there. More often, it's an issue that the pipeline hasn't been activated, that you haven't had a clear statement from leaders that this is something that we value, that will be seen as a true value as in the course of assessing potential candidates for the bench, and it's something that we're going to actively prioritize. There's also broader reforms, some of which are things that courts can do on their own, some of which require state legislatures, some of which would require constitutional amendments, but all of which can help address some of these outside threats that I was talking about. That includes everything from introducing public financing for judicial elections, so judges aren't having to dial for dollars all the time, to introducing stronger recusal rules and ethics rules, something that in most states is within the power of courts to do on their own typically. And it's also about stepping back and thinking, is it time to rethink judicial selection? Rethink how we're doing it in particular states and perhaps consider more ambitious initiatives to adopt publicly accountable nominating commissions for judicial candidates, to think about addressing the reselection pressures that judges are facing by having perhaps a lengthy single term for judges rather than having to routinely stand for election. There's a lot of really interesting reforms that are out there that we can build political momentum around and take steps to really further bolster our courts and safeguard them against pressures that impact that public confidence in equal justice under law. There's also a big piece of this that's about public education and mobilization. This picture is from North Carolina. I mentioned when I was talking about some of the assaults on the courts from legislatures that there had been a failed attempt to gerrymander judicial districts in that state. And part of the reason why it failed was that there was a very strong public outcry and public scrutiny about what the legislature was doing. A call to action that was not an appropriate thing, that we don't want courts, we don't think it's a good idea for legislatures to be trying to rig how district lines are being drawn for our courts, that should be set out from politics. And one of the reasons why I love this picture is because you actually have people holding protest signs saying fair courts, that this is an example where something that, I'll be honest, courts can be a little wonky sometime, right? Like courts can feel very abstract, very technical. But this was an example where, because of a very well-organized campaign, people were able to make connections with members of the public to understand the stakes, understand why it matters for democracy, and actually got feet on the ground, got people to come out and say, we object to this, and we're going to fight for fair courts. They held up those signs. And I'll do a shameless plug for the workshop that I'm going to be involved in at 2 p.m., because we're going to talk more about some of those examples and some of the public messaging that's been successful in states who have sought to defend their courts against those sorts of political attacks and really mobilize the public. Because I think one thing that's really clear, people in this room, all of us, we are essential, but we're not sufficient. We need broad public engagement, public support to understand the stakes for our democracy of fair courts, judicial independence, and the need to ensure enhanced access to justice and protect courts from those external attacks. I think what we've seen from research is that there's pretty widespread latent support for concepts like checks and balances for the role of court. If you ask people and you get them to think about it, most people say, yeah, we want to have courts. They're important. We don't want them to just be politicians. We need to have this separate branch of government, and it's not good when they're put under political pressure. But the problem is that that is often very latent. And the challenge is, how do you activate it and connect it with real things happening in real people's lives so that it's more than just sort of a passive support, but something that people are really willing to come out and demand? One more shameless plug, which is an effort that the Brennan Center is doing to encourage more public education about the role of state courts, particularly around state constitutional development. We're building a page. Right now we're piloting content, but are building a website that we're hoping will be a real hub of information about courts' rulings, what courts are actually doing, with a database about notable decisions and lots of commentary talking about trends that are coming out of state courts. So we're hoping that that's one way that we can start building more public interest and engagement about what's happening in state courts and helping people to make some of those connections and understand the stakes. And I very much hope that we can all here be partners in some of those efforts, because I think that public education piece, that public animation around this is really important, and courts are worth fighting for and worth making better is really critical and something that we all have a role to play. So in conclusion, Chief Justice Roberts famously compared judging to calling balls and strikes. But of course, as we all know, judges also define the strike zone, and court managers and our court systems as a whole impact who even gets a turn at bat, who even gets let into the stadium to begin with. I'm just going to keep running with that metaphor. Justice Sandra Day O'Connor reminds us that the courtroom is supposed to be the place where fairness trumps strength, where the law is what matters, not who's powerful, not who's well-connected, not who's popular. We are at a critical moment for the future of our courts and our democracy, and it is up to all of us to hold power to account and to demand a more just system for everybody. Thank you so much for the opportunity to speak with you all here today. It really has been an honor.